So welcome everyone to today's University of Texas Energy Symposium, sponsored by the Energy Institute. I'm Kerry King, research scientist and assistant director here at the Energy Institute, and it is a pleasure to have Alex Klass with us today. Before I introduce her, I will indicate some of the upcoming talks. In 1 week from today, we will have Dan Dalton, who will talk about sustainability and autonomy for interconnected future of modern flight. He's involved in urban flight planning and these kinds of things. So we don't technically have the flying cars yet, but I think he's trying to think about that a little bit in his work. And then the week after, October 29th, we don't know the exact topic, but we will have Joe Kiesecker, who's the lead scientist at the Nature Conservancy. But today we have Alex Klass. She's the James G. Degnan Professor of Law at the University of Michigan Law School. A little bit background on Alex. She teaches and writes primarily in the areas of energy law, environmental law, and natural resources law. And in 2022 and 23, she did serve in the Biden-Harris administration as Deputy General Counsel for Energy Efficiency and Clean Energy Demonstrations at the United States Department of Energy. So if we want to know something about how law and policy affect the build-out of the electric grid, that is who we have here with us today. Her scholarly work addresses regulatory and permitting challenges to integrating more renewable energy into the nation's electric transmission grid, citing and eminent domain issues surrounding interstate electric transmission lines and oil and gas pipelines, as well as applications of the public trust doctrine to modern environmental law challenges. She's a co-author of 3 books on energy law, and prior to her academic career, she was a partner at Dorsey Whitney LLP in Minneapolis, where she specialized in environmental law and land litigation. So today's talk, she will talk about state public utility regulation in the energy sector and the rapid transformation that it is undergoing, driven by the unprecedented levels of federal funding for clean energy deployment, the urgency for decarbonization due to climate change, and increasing demands for environmental and energy justice. So this crosses many aspects of societal well-being. And for decades, however, state utility regulators have protested that their role as economic regulators excludes a central role for her, quotes, social policy. So she's going to discuss with us that state policy utility regulators are, and they always have been, social policymakers that respond to the emerging conditions of the goals, and they are not limited in some of their monopoly powers in the way that they might think. So with no further introduction, I will now pass it over to Professor Klass and stop sharing. Oh, was I even sharing? Oh, stop sharing my screen and let her go through. I will point out that we will hold questions until the end of her presentation. And if you want to ask a question verbally, we will try to do that by seeing if you could raise your hand. And I will call on you if you have risen your hand to ask a question at the end. But as always, you can type the question into the question and answer feature of Zoom. So with that said, I now pass it over to Alex Klass. Go ahead.
Thanks, Kerry, and hi, everyone. Can you see my slides? I'll let
I do see them, yes.
Okay, great. So it's wonderful to be here, at least virtually, with you today. I'm mostly going to be presenting this new paper that I have with Professor Gabe Chan, who's a public policy professor at the University of Minnesota at the Humphrey School of Public Affairs. This is the second paper that we've written together, and at least as for now, the paper is entitled Reckoning with Social Policy in Utility Regulation. This can be the first time I presented it, and we're still working on the paper. It's not up on SSRN or anything like that yet. So I'm actually really looking forward to the Q&A at the end, getting your reactions, things, parts of it that you find convincing or not convincing, other things that we should be thinking about. So definitely both presenting the paper, but hoping to treat it kind of as a workshop as well, and get your thoughts. So, you know, some of the topics that I'm going to touch on today and that are discussed in the paper is this sort of broad topic of the role of state utility commissions as social policy makers, and also just how social policy integrates into what state public utility commissions do. And I'll, after sort of introducing the topic, I'll talk about some historical foundations of just public utility regulation generally, but then give some kind of early precursor applications from the, I'd say, kind of the mid-late 20th century, involving low-income rates and economic development rates, where a lot of these social policy issues come up either expressly or impliedly, and how commissions deal with that. Then in the paper, we have sort of two contemporary applications of this topic. And the two that we've picked are energy justice, as more and more commissions are needing to deal with energy justice issues, both in rate making as well as in grid modernization issues, and just how we are kind of distributing new energy resources, particularly distributed energy resources, who is paying, who is getting the benefit of those. And oftentimes this comes under the broad topic of energy justice, which is actually kind of a new term. Environmental justice has been around for a long time, and oftentimes people will sort of refer to them together, but they really deal with sort of separate topics that I'll talk and separate issues. And then another main sort of contemporary application that's coming up a lot in state public utility commissions is how commissions are supposed to deal, along with legislatures, about what has tended to be called just transition, sort of socioeconomic issues. As we, engage in a clean energy transition, there are a lot of communities, particularly fossil fuel communities, where this has really significant socioeconomic impacts in terms of jobs and tax revenues. How do we transition those communities? What obligations are there, both in terms of the utilities themselves and the larger society towards those communities? And the literature around that often uses the term just transitions. So this is another area where we see social policy really integrated into the work of state public utility commissions, both in integrated resource planning, in rate-making decisions, and other sorts of things. I'll touch briefly on kind of equity and grid modernization issues, which is something we talk a little bit less about in the paper, but I know is a topic that many people are interested in. And then at the end, I'm gonna sort of end with what Gabe and I think are some of the implications of more expressly recognizing social policy as a component of utility regulation. So with that, again, the sources for this work, one is a paper that Gabe and I published a couple years ago called Regulating for Energy Justice, that really looks exclusively at how state public utility commissions are incorporating energy justice ideals and principles into their rate-making decisions and other decisions, sometimes on their own, sometimes as a result of state legislative mandates. And so we decided to write this new paper to do really two things. One is to kind of update some of the information on energy justice. So this was kind of a new topic when we wrote our paper back in 2022. And now, at least in some states, the issue has really exploded. And so we wanted to kind of update what commissions are doing with energy justice issues in this new paper, but also broaden it and look at a broader range of social policy issues that utility commissions are dealing with. So that's kind of the goal of this second paper, and that's primarily what I'm going to be focusing on today. So to start, I know not everyone on the webinar is a lawyer and deals with laws, but there are these sort of overarching laws that govern the regulation of monopoly utilities. And typically we're talking about regulating what we call public utilities, which are not owned by the public, but are publicly regulated. So basically our private investor-owned utilities. And you'll see that the language between federal regulators and different state regulators in general is actually quite similar in terms of both the mandate and the obligation and discretion that commissions have. So at the federal level, the Federal Energy Regulatory Commission has authority under the Federal Power Act, which was enacted in 1935. And this language that's quoted here is not been changed since 1935, that all rates and charges may made, demanded, or received by any public utility, again, these are private investor-owned utilities, shall be just and reasonable. So just and reasonable is kind of the touchstone of rates, and it's up to FERC to determine what are just and reasonable rates. And that same kind of language you see in almost every state's legislation delegating similar authority to state public utility commissions, because one thing that the Federal Power Act does is gives authority to FERC. Back in the old days, it was the Federal Power Commission, but since 1977, it's been the Federal Energy Regulatory Commission, that FERC has authority over wholesale sales of electricity and the transmission of electricity in interstate commerce. And this interstate commerce is important for many of you because that, as you probably know, that does not include Texas. So the Federal Power Act, these provisions do not apply to Texas because Texas has, sort of walled itself off from the rest of the grid. And so therefore the wholesale sales of electricity are not in interstate commerce, and transmission of electricity is not in interstate commerce. Same, of course, with Hawaii and Alaska for geographic reasons. Texas, I actually don't have the Texas statute up here, but I'm assuming there is just and reasonable language in terms of the Texas Commission regulating retail sales of electricity and retail transmission of electricity. So the Federal Power Act divides up regulatory authority. Federal government is wholesale sales of electricity and interstate commerce and transmission of electricity, and states remain in charge of retail sales and retail transmissions. And the only retail transmissions that exist in terms of not being on the federal side are the ones in Texas, Alaska, and Hawaii. But I'm giving you the language of sort of the two M states that I still live in. Currently, I'm in Michigan, but I was on the Minnesota law faculty for about 20 years. So you see the Minnesota Public Utility Commission has direction from the state legislature that tells it that every rate made, demanded, or received by any public utility shall be just and reasonable. Rates shall not be unreasonably preferential, unreasonably prejudicial, or discriminatory. And you see, the Minnesota law also talks about setting rates to encourage energy conservation and renewable energy use. That, of course, does not exist in all states. It does exist in Minnesota. And then the Michigan Public Service Commission has delegated authority from the Michigan legislature to set electric utility rates that are just and reasonable. And then also this sort of non-discrimination provision, basically that a consumer shall not be charged more or less than other consumers for similar service rendered under similar circumstances and conditions. So what this tends to mean in states is that the commission can have different rates for industrial, commercial, and residential customers, but within those customer classes, you can't have unduly or unreasonably discriminatory rates. You can't discriminate, at least unduly or too much, between customers within a class. And I'll be talking about that a little bit later. So, all of these provisions here, these are legislative provisions that give delegated authority to, at the federal level, the Federal Energy Regulatory Commission, and at the state level to whether it's state public service commissions, public utility commissions, they do the same thing. They just have different names from state to state. But this just and reasonable rate-making authority is common, and then almost every one of these statutes, I don't have it up here on the slide, but basically the legislation directs the commission to make these decisions in the public interest and to protect the public interest. Okay, so based on that, what's the role for social policy? Before we talk about that, of course, we need to define what social policy is. And obviously can mean broader and narrower things depending on the context. But at least for our purposes here today, I'm defining it as, at least in the context of utility regulation, these are going to be non-energy state and local socioeconomic concerns. So that can include job creation or tax revenues or economic development. Also things like energy justice in terms of really focusing in on the past and current inequities regarding how electricity service has been and continues to be provided to different communities and different types of individuals. So this is sort of looking broader behind the just the focus on costs and benefits of the system and how to divide that up, which is clearly within a commission's jurisdiction. How is a commission supposed to look at some of these other social policy issues? So you see the examples below. We kind of divided into kind of past and future inequities, with energy justice kind of representing a social policy that's looking at past and current inequities regarding electricity service. And then the just transition piece is often looking at future inequities. How do we ensure that communities are sort of not left behind as we engage in an energy transition, as certain energy generation plants close down and other ones are created. So you can kind of look at this in a temporal way. So one of the things that I find fascinating in this research is how the term social policy is thrown around by the courts, by advocates, and by commissions in contested case proceedings. Because a lot of these rate-making proceedings and also in some integrated resource planning decisions, you actually have a trial-like proceeding in front of an administrative law judge where testimony is taken, cross-examination is done, different parties and stakeholders can participate, so a broader group of stakeholders than you would have like in a lawsuit that's in front of a court. And then the administrative law judge creates an entire administrative record based on that. It then goes to the commission, and the commission can adopt the administrative law judge's recommendation or not, and that's in a very often lengthy written opinion. And then, of course, if there are parties that don't like the commission's decision, they can appeal that to state appellate courts. So in these proceedings, again, both in front of the commission, often between commissioners, and then in terms of court review decisions, you see a lot of sort of warnings to commission. It's not your job to make social policy. You're engaging in social rate making. You're an economic regulator, or a commission saying, we're an economic regulator. We feel really bad for these stakeholders who are showing how the system is inequitable for them, but that's not our job. Go see the legislature. The legislature makes social policy. We just do economic rate making. So you see a lot of this back and forth about what is and isn't social policy and whether it's appropriate. So a big question for our research is, what is the role of the legislature, state commissions, and courts in addressing social policy issues, particularly in this context of state public utility commissions that have this really broad mandate to ensure that we have just and reasonable rates and to work in the public interest? How much authority does that give commissions in terms of dealing with these issues, or how much do they need an express legislative direction to deal with just transition, to deal with energy justice? And how do we address these past and these future inequities? Is that within the scope of what state commissions can and should be doing? So part of the challenge that we find to addressing the role of social policy in state utility regulation is these are really sort of technocratic processes, and we sort of give examples of that in the paper in terms of how commissions are doing their market evaluation in oftentimes a situation where there is no real market. Basically, you're regulating monopoly utilities and allowing the commission to set rates and make these decisions because there isn't a market, because it's a monopoly. And so, I mean, and even in Texas, that has a lot of retail choice for electricity, this is how Texas does it with regard to the transmission and distribution system, which is still monopoly even in Texas. And of course, Texas has moved the most away from kind of monopoly utilities and monopoly provisioning of services of any state. But even that component of the electricity system is still this monopoly regulation. But so as a result, you've got all sorts of very difficult processes, and it is made to seem as if these are just sort of purely economic technocratic exercises. But that's not the case, but it's hard to sort of push and see that. So, the idea of cost causation, that customers should only be paying for for the benefits that they receive. That's kind of a basic principle of regulation, both at the wholesale level and at the retail level, so both the federal level and the state level. But that principle is often applied very inconsistently. There's a lot of cross-subsidization between different classes of ratepayers, between industrial, commercial, and residential customers. But oftentimes that's hidden behind a lot of these technocratic processes. There's a concern that, if rates are only being based on costs and not benefits, how are we making sure that this is actually working in the public interest and these rates are in fact just and reasonable? And there's no real definition of what it means to work in the public interest. So we don't have a lot of really good definitions. And I think it's very difficult to get behind a lot of these technocratic, particularly rate-making processes, both in terms of having stakeholders be able to participate in these proceedings, other than the utilities that have a lot of experience and resources to do that, and maybe some of the larger industrial customers. And these are just much more difficult proceedings because you need the economics background, you need the engineering background, and so social policy can kind of hide behind those processes. So, we start with some historical foundations in the paper to talk about just the long history of both federal and state commissions kind of working in the public interest. Why were they given this authority to work in the public interest to regulate monopolies? And this goes back to the 1800s. I cite, the Munn versus Illinois is the regulation of grain elevators by the Illinois legislature that was upheld. Nebbia versus New York is kind of one of the early New Deal cases. And basically this is, more from the 1930s. And in those cases, the Supreme Court and in others upheld the power. At this point, it was state legislatures who were trying to regulate rates and prices of companies whose business was deemed to be clothed with a public interest and to be working in the public good. So the Munn versus Illinois case, talks about how all of the grain elevators bringing grain from the Western US to the East Coast, they have to go through Chicago. You only had a few owners of these grain elevators, and every year they would get together in a smoke-filled room and decide what the prices would be. There wasn't enough competition. The legislature in Illinois decided it was going to regulate those prices. Of course, the companies didn't like it, challenged it, and the Supreme Court said, that's okay, legislatures can regulate prices. Later cases in the early 20th century, again, during the New Deal, really broadened the scope of price regulation to a broader scale of industries, and also kind of survive the shift of, you might think it's not very efficient for legislatures to be setting prices. So what legislatures started doing was delegate that authority, delegate price setting or rate making authority and rulemaking authority as well to these newly created public utility commissions, telling them they were delegated to act in the public interest. And this is where we get our early language about the authority to set just and reasonable rates. So that kind of went along for many decades in the 20th century. And then the law and economics movement comes around, some of the deregulatory politics of the 1970s. There's some Supreme Court decisions. One involves the NAACP versus the Federal Power Commission. We'll talk about that in the paper. I can answer questions about it later. But basically, these cases both limited the scope of industries that were subject to this type of regulation. Think about kind of the deregulation of the railroad industry and the airline industry. The financial sector, that regulation of that has sort of gone up and down. And also some cases that kind of more limited the authority of public utility commissions to really they're narrowing their public interest authority to what the real goal of their statute was. So if in the case of the Federal Power Commission, it's really the court said it's really to regulate monopoly power. And so we don't think that the Federal Power Commission has broad authority to regulate discriminatory employment and practices of the public utilities, which is what the NAACP was arguing. So, this trend, I think, had the effect of reducing the ability for commissions to think that they could really use their fact-finding, their regulatory authority, and really what is quasi-judicial authority to set or to evaluate social policy as part of their public interest mandate. So we saw this sort of ascension of public interest regulation by commissions, kind of followed by decline in the latter part of the 20th century. So part of where you see these contestations is in these low-income rate cases that Gabe and I talked about to some extent in our first paper on energy justice, and we bring back as a nice example in this second paper as well. And these were cases that were going on sort of all over the country as electricity prices started to rise in the 1970s. Costs were increasing. The industry wasn't expanding as much. We had the Arab oil embargo. There was a lot of uncertainty in the energy sector. And so in responding to this, you started having a really high energy burden on lower income residential customers, on senior citizens. And so you had commissions that were often asked to set low income rates, a separate rate within the residential ratepayer class for low income customers or senior citizen customers. Sometimes the utility itself was proposing that rate. Other times it was low-income advocates that were proposing the rate. But a lot of these rates actually were proposed by the utilities themselves. So the Utah example is kind of a classic one. The commission had authorized a senior citizen rate in 1979, and then it was challenged, and the state Supreme Court responded to arguments that said that the commission was not empowered to act on the basis of social policy. You can't subsidize one consumer group over another. The legislature could set a low-income rate, and around this time and later, several state legislatures did do that. Our question here is, when can a commission do it on its own? The court, though, said, we don't think you, the commission, put together a good factual record to support this. So you could try again, but right now, we're accepting the arguments of the opponents of this low income rate. So the commission took the court up on its offer and did some additional fact finding, and actually was able to build a record that said, if we have a lower rate, that's going to lead to fewer disconnections. That's going to lead to uncollectible accounts. And actually everyone saves money if we have that. Because once you have there's a lot of costs associated with disconnecting customers and then reconnecting them. And if you have uncollectible accounts, those are going to get spread over the cost of remaining ratepayers as well. So actually you save a lot of money overall for all ratepayers in that residential class if you have a low income rate that prevents or minimizes those disconnections and uncollectible accounts. These same issues and same disputes are going on today, and that is a lot of the data that supports low income rates. This became a real problem during the pandemic when a lot of people lost their job, weren't able to pay their energy bills, and both legislatures, commissions, utilities, and governors stepped in with low income rates. This was obviously before that. But one of the things the commission said in its second order was sort of recognized the malleability of kind of social policy, social welfare. There's a great quote that says, examples abound to demonstrate that one person's improper social welfare program is another person's legitimate regulation of utilities in the public interest. So that commissions really do have this authority to make these distinctions as long as they have a good factual record, and do that as part of their just and reasonable rate authority in the public interest. Similar phenomenon in Colorado right around the same time. Commission approved a low-income gas rate and said, you've got very limited authority to have a rate structure that's designed to provide financial assistance as, again, they use the term social policy, as a social policy to a narrow group of utility customers where that low rate is financed by its remaining customers. So again, focusing in on that non-discrimination provision that you saw in the earlier in the statutes that I cited to earlier. Strong dissent by one of the justices said basically, this really broad legislative authority to the commission. That authority includes the power to initiate public policy. There can be discrimination and rate differentiation. It just can't be undue discrimination. It can't be too much, but there can be some. Later on, the commission sort of interpreted the language of the decision to say, well, we still have fundamental fairness as a goal of regulation. And if a good low-income rate is presented to us, we think we have the authority to implement it. So, you know, these issues, these low-income rate issues, in some states, they're not controversial in the sense that, like, the legislature has said the commission can set low-income rates. Michigan actually has a law that says that. Though we're not as interested in those cases, we're really interested in the cases where the commission just has their just and reasonable rate-making authority in the public interest. What do they do with that? What does the back and forth look like in the commission, between the commission and the legislature, between the commission and the courts? And we really see that as kind of an ongoing conversation between those branches of government. Now, right around the same time, commissions are addressing similar social policy issues, but in the context of economic development rates. And you would think the same debates would happen here. You're looking at social policy to set a rate, but oftentimes these ones kind of sail through. So Kentucky is an example. The commission in 2008 basically approved a discount rate. So this is an idea. The idea of economic development rate is you give a lower electricity rate to a company or an industry or a manufacturer that says, hey, we will come and create jobs and economic prosperity in your community, but as an incentive, kind of like a tax incentive, as an incentive, we'd like a lower electricity rate. And oftentimes commissions jump at the chance to do that. So here's one where there was legislative authority for a very narrow set of circumstances. Basically, if you redeveloped a brownfield site, you could get an economic development rate. The legislature had said that. The commission decided to approve an economic development rate, a discounted rate for any customer that provided new electric loads, even though the state had that, the legislature had that no unreasonable preference, no unreasonable discrimination statute. Kentucky Supreme Court said, looks good to us. Lots of other commissions in other states, I list a few of them here, have authorized discounted electricity rates for new industrial customers, not because there's legislative authority to do it, but just under their just and reasonable rate-making authority. The idea is there's broader positive impacts to all ratepayers. You're spreading the overall system costs more broadly. You're promoting jobs and economic development. That's all great, but in our view, that's just as much a social policy as the economic development rates, but it's not recognized as much in these decisions. Okay, so those are kind of our precursor examples, things that were happening kind of in the latter part of the 20th century and the early part of this century. Now we move to contemporary proceedings that we think illustrate how social policy is addressed and could be addressed by state commissions. So one is energy justice. And just for those of you not familiar with the term, here's a definition from the Institute for Energy Justice, and it's the goal of achieving equity in both the social and economic participation in the energy system, while also remediating social, economic, and health burdens on those historically harmed by the energy system. And there's kind of these four tenets of energy justice. It's kind of the who, how, what, and why of energy justice. One is termed recognitional justice. So the idea of identifying and advocating for communities that are ignored or misrepresented in energy decisions. These are often low-income communities. These are also racial minority communities that often have just historically and today have much worse electricity services in terms of reliability, in terms of outages, in terms of not as much investment by the utilities in energy efficiency and weatherization. So sort of recognizing these communities and just recognizing the fact that they have not been treated the same as wealthier or white communities in the provision of gas and electric service. Then there's the procedural justice aspect. I talked about how difficult it is to participate in commission decisions and in just the whole process. How do you ensure that there is an equitable decision-making process and that these communities and their advocates have the resources, sometimes through intervenor funding, to actually participate? And how do you make these processes more transparent rather than opaque? Distributional justice. So what are we actually talking about? And it's really ensuring that the benefits and the burdens of the energy system are more equitably distributed. So if there's going to be investments in distributed energy resources like rooftop solar or our energy efficiency upgrades, those are often funded by the utility at the behest of the commission. Are those going to the right communities? And perhaps we should be giving more resources to the communities that were not able to take advantage of those resources because of redlining and other things in the past. And then restorative justice, like why are we even doing this? The idea is responding to past harm and current harm that are caused by the energy system where we have power plants, where there's been underinvestment, and then try to figure out change to prevent future harm. So one of the things that Gabe has done, and he gets total credit for these next couple slides, is he's had some research assistants actually document where energy justice is coming up in state utility regulatory proceedings and how often. And you see basically the issue has just not come up until very recently. And then starting in really 2019, 2020, 2021, you see stakeholders raising the issues, commissions on their own raising concepts of energy justice, and issuing decisions with regard to that. Part of the reason of the increase is Gabe himself has been actually testifying in a lot of proceedings across the country to urge commissions to engage with energy justice, and that has been successful. So these maps kind of show where that is happening. Both, proceedings where the parties raise energy justice, and then also proceedings in which the commission orders actually address energy justice as well. And then this looks at the type of regulatory proceedings where this is happening. You see a lot of it's happening in rate cases. So the very lengthy proceedings that set utility rates and charges that we and all utility customers ultimately get charged for, but also in resource planning decisions, distributed energy resources, distributed energy resource rates. So for instance, compensation for rooftop solar, grid modernization issues, community solar, energy efficiency. So you're seeing it come up in a lot of different types of state commission proceedings. So we have sort of two big examples in the energy justice section of the paper. We look at, examples from commissions that have a statutory mandate where the legislature has actually said something about equity, environmental justice, and where the legislature has not. So, there are an increasing number of states that have directed commissions to consider either equity or energy justice in their rate-making proceedings or other proceedings. And I list those states here. And so I just give, an example from Colorado. And so how this plays out in Colorado in terms of how the commission is supposed to direct utilities to provide 40% of funds for various programs to benefit low-income customers and disproportionately impacted communities, expressly to address historical equity issues concerning access by low-income customers to these types of benefits. So that's just one example. Every state's a little bit different. So in terms of an example of a state commission grappling with these issues when they have a statutory mandate, we use Washington. And so this is a decision just from a couple years ago. So in that case, the legislature enacted a statute that expanded the commission's public interest standard to include the equitable distribution of energy benefits and reduction of burdens to vulnerable populations and highlight impacted communities. So what did the commission do with that? It actually took that general language in the statute and said, we think the way to implement that is to adopt those 4 core tenets of energy justice that I had on an earlier slide. And so utilities, you need to take these energy justice ideals into account, and we're going to hold you accountable for that. And so then in a later order, the commission approved a utility proposal. Utility had to come back with a proposal, and it was going to create several equity metrics in its performance measures and in its outcomes in terms of tracking the average energy burden of customers, and kind of setting a 6% threshold for energy burden concerns. And those of you who work in this field know that like 6% of kind of income is considered, if you're paying more than 6% of your income towards electricity, towards gas, towards energy services, that's considered an energy burden, and you should be eligible for certain types of services because that's just too much. Lots and lots of communities, lots and lots of individuals pay quite a bit more than that, and it really varies by state. Okay, so that's sort of what Washington did with their legislative mandate. Minnesota is the example of one where there's no legislative mandate with regard to equity or energy justice, but advocates asked the Minnesota Commission in a rate-making proceeding by Xcel Energy, which is the major investor-owned utility in Minnesota, to basically require Xcel Energy to address energy justice in rate-making. And they said, the commission, you have authority to do this just under your regular just and reasonable rate-making authority in the public interest. And the Public Utility Commission in a 2023 decision agreed that under its general authority, it could require and would require utilities to expressly incorporate those 4 energy justice tenets into future rate-making proceedings. The commission had already set up a parallel kind of commission-supervised equity stakeholder advisory group for Xcel Energy and a lot of stakeholder groups. And, Xcel's response had been, hey, we think energy justice is really important, but we think we should deal with that in this separate proceeding, this ESAG proceeding, not as part of regular rate making. And the commission said, nope, we think you need to do both, which we think is important because you have these trial-like administrative proceedings where you're actually taking evidence in the rate-making proceeding, not in the ESAG proceeding. So I think you can actually hold participants a bit more accountable in the rate-making proceedings. So fast forward to this year, and Xcel Energy actually came up with a really innovative program that it really came out of the ESAG group, but then Xcel sort of put it forward to the commission to approve. It has not been approved yet. But so they came up with a 2-year pilot project that basically gave monthly electricity bill credit, so reduced electricity bills to every household within the U.S. Census block groups across their service territory. And it's, mostly the Twin Cities and the Twin Cities metro areas, Xcel's territory, where the electric energy burden was above 4% of the gross median household income. This is significant because it was doing it by geography rather than making individuals apply for bill credits. And so it'd be about 23,000 households and pretty significant amounts of money, particularly for low-income households, about $450 per household per year. How should it be funded? Not necessarily directly from other residential ratepayers. They figure the yearly program cost would be about $5.5 million. And there's a big settlement between Xcel Energy and other electric utilities that own nuclear plants and the Department of Energy over the failure of Yucca Mountain. Basically, they all had to pay in to this federal fund to build Yucca Mountain to store used nuclear waste. Of course, as you know, Yucca Mountain was never built. So a lawsuit was filed to say, hey, we want our money back. And the multiple circuit courts said, yep, you get your money back. So every year, federal government pays money back to the utilities. And so Xcel Energy, instead of spreading that money across everyone, says we're going to, at least for the next 2 years, if the commission approves, use it to support this program. So we'll see if that gets approved. There was an interesting legal analysis in Excel's filing as to why this was not unreasonably preferential, prejudicial, or discriminatory, which is the standard. And they said one of the reasons that it met the standard is because it has the effect of addressing past discrimination, not by them, not by Excel, but because of systemic and long-term societal inequities that have led to geographic concentrations of poverty, older and less efficient housing that increase energy costs, lower incomes, fewer job opportunities, and other disparities. So it concluded, while the program may be considered preferential, if it is, we believe it is reasonable and in an anti-discriminatory direction. So this is the argument of the utility as to why a program like this would be legal. So we'll see what the commission says, and we'll see what a court says if it gets there. Okay. Next question that we address is kind of the role of socioeconomics in integrated resource planning. So we're moving from rate making to integrated resource planning. And we've got kind of integrated resource planning processes in a lot of different states where basically utility forecasts its demand and identifies how it's going to build power plants, buy power to meet that future demand. Very complicated process. Texas uses markets for all of this, but lots and lots of states have some sort of an IRP process. And the policies that are embedded in IRPs tend to reflect state politics. So in some states, you've got a presumption in favor of coal-fired generation in the IRP statute to promote coal economies. You've often got a presumption in favor of clean energy investment in states that have a clean energy standard or an RPS. So there's kind of a history of coal states, particularly in the 2000s, approving very costly kind of clean coal plans based on the likelihood of both future federal carbon regulations and also preserving local jobs and economies. And you've got PUCs and legislatures in progressive states that say, hey, we want you to incorporate the social cost of carbon. So here's like these different state policies coming into integrated resource planning. Contemporary applications tend to be around just transition. And I've got a definition of just transition here. Let's see, I'm going to move through the rest of these slides a little more quickly so we have time for questions. But this is becoming a bigger issue for commissions, and they're sort of being forced to address what are the implications of the clean energy transition on state communities. So we give an example in the paper from Wyoming, where Wyoming reviewed an integrated resource plan from Rocky Mountain Power, which is a subsidiary of Pacific Corp, where Rocky Mountain Power was going to close 16 coal-fired power plants in Wyoming and basically replace it with market purchases, renewable generation, batteries, energy efficiency. They had done this coal study that the Oregon Commission required them to do. Here you have environmental groups urge the commission not to take any account of social policy, just make an economics-based decision. And then you have local governments and others actually wanting the commission to take into account community tax revenues and jobs. So you sort of have parties kind of switching sides here, with the environmental groups saying, you're only an economic regulator, pay attention to the low-cost new renewables. The commission said, this is really tough. We're not sure what to do. We are a traditional economic regulator. We're not supposed to consider socioeconomic impacts, but we're actually going to do it anyway. We think it's ridiculous that the Rocky Mountain Power would close all these coal plants and not weigh the economic devastation caused by these early retirements to its longtime workers, to its communities. And we're rejecting your IRP, and we want you to come back and think about adding carbon capture sequestration to these plants. New Mexico really reached the opposite conclusion. There was a statute that basically was intended to try to close the San Juan generating station and have a just transition there. The city of Farmington, which was the host city for the coal plant, said, no, we don't think that the utility should be able to abandon this coal plant. We think we should all work together to install CCS. The commission approved the utility's request to abandon the plant, said the city could try to work with a third party to keep the plant open. That has not worked, and the coal plant has closed. So these are sort of two different commissions working with different statutory authority dealing with the role of CCS in an integrated resource plan and all of the social policy issues that go along with that. I'm going to skip through these equity and grid modernization slides really quickly and just kind of give you some of the implications and just do that very quickly. And that gives us, I think, about 10 minutes for questions. So I sort of divide into three categories some of the implications of actually recognizing the role of social policy in utility regulation. One is, and I'm interested if anyone on the call thinks this is too much of a stretch, I think it has implications for the growing literature out there on what are often now known as networks, platforms, and utilities. There's a new legal casebook about that. It basically is reviving what used to be the study of regulated industries. And basically, this new literature is drawing parallels between kind of the history and social infrastructure aspects of energy, water, postal service, railroads, telecom, and also banking and credit card platforms and internet platforms. And asking, should more of these industries be subject to public utility regulation? Because we kind of have almost new monopolies in our society. That raises the issue of, well, there's a lot of criticisms of how public utility regulation works today in industries like energy and water. These are not perfect. Should we be expanding it? But I think this is a really fruitful area of legal and policy scholarship. And I think some of the implications in our paper have some insights that can be helpful in that conversation. Implication number two is really doctrinal. So if state commissions should be recognized as a legitimate social policymakers alongside legislatures, we think that should argue for courts granting commissions more deference to make that policy and allow the legislature to act as a correction, not courts, because of the important role of commissions is really acting as a forum for evidence gathering and stakeholder engagement and as a policy incubator with more back and forth with the legislature than you see at the federal level. So we think that this could lead to a new approach to deference to state utility commissions. And then the last implication is really about process and really seeing these commission proceedings for what they are as kind of these action situations where diverse stakeholders can form coalitions, develop kind of deep knowledge over time, and invest in networks. And we really see new advocacy groups forming around the country to raise the profile of state commission work. A lot of commissioners are elected rather than appointed, and to really allow more stakeholders to engage in that work. So I'm going to stop sharing my screen here and stop talking for now, and would love to hear questions.
All right. Well, thank you very much. As a person with an engineering background, I was trying to soak up a lot of what you were saying there and a lot of questions myself. So please submit questions. There's at least one very active person on the YouTube submitting questions, and I'll try to go back to one of the earlier ones, which is you provided a lot of examples. So maybe this isn't fair to just ask about another example, but maybe it enables you to emphasize some things or bring up a new point. But it's the issue of California. However much you know about what's going on in California. So let's just say relatively progressive on renewable goals. Some of the highest prices in terms of cents per kilowatt hour for, let's just say, residential customers. And California's got a lot of different climate zones, and I think their rates try to address these different climate zones if you're on the coast versus if you're in the middle and you consume more, and the lower income people tend to be in the sometimes the center of the state. So is this an example of the challenges to come? If people think that there's sort of not energy justice, well, at least, I don't know, I guess support for low incomes in California. I don't know, what are your thoughts on that? And your examples of utility commissions thinking about energy burden as a metric and shifting around funds, I thought was very interesting. But I'm trying to phrase this person's comment as a semi-question. So any comment about what's going on in California?
Yeah, so
evidence for energy justice being, the energy transition causing high rates. This would be a common response.
Well, so I mean, it's a lot of the states that are sort of most active have often had high rates in the past. It's always hard to know. This is like, the debate you have over whether like restructuring lowers rates or raises rates. You can, you have evidence of both. Mostly it was, the states that restructured had high rates to start. And would their rates be higher if they didn't, right? And, you have advocates on both sides. But particularly with regard to sort of equity and low income rates in California, one of the reasons we don't talk a lot about California in the paper is because California does a lot of this through the legislature. So the legislature can always set these policies, and the California legislature is really active. So that's, from a legal perspective, that's an easy question, right? The legislature can do it. You can decide it's a bad policy or good policy, but it says Public Utility Commission, here's the policy, implement it. And so in terms of us focusing on what kind of inherent authority does the commission have, California is not a great example. However, what it is a good example of is even when the legislature is setting that policy, that doesn't make it uncontroversial. And we actually have a little paragraph about it in the current draft paper. So, as at least the questioner probably knows, and maybe others, the California legislature told the commission to sort of implement some more aggressive low income rates. And so the commission came up with sort of different tiers in terms of income tiered fixed charges and electricity rates, and everybody's all up in arms about it. Is really and they're going to try to go back to the drawing board because there was a lot of negative reaction to it. There's an example of where even if the legislature is doing it, that doesn't make it uncontroversial. These are very contested issues as to how we should be sharing the burdens over systems that we need for modern life, right? Electricity is not, it's not a luxury good. I think California is a great example of more express grappling with those issues and doing that on a legislative level. But the commission still, and we give some other examples, Illinois too, the legislature's been very active. But it's ultimately the commission that's going to need to implement it. And often there are times that's where you're going to see all of the fact finding. You're going to have a, contested case proceeding. So even when the legislature is active, you've got the commission as sort of the locus and the forum of where that action is happening.
Great. So a question here. When it comes to integrated resource planning, what do you see as the best way to affordably meet demand while keeping in mind these 4 tenets of energy justice and environmental justice? You earlier in your talk, you sort of described how they're different. You might summarize how they're different if you can. And so do you see energy justice and environmental justice at odds with one another in the context of, integrated resource planning and maybe more renewables and low carbon supply?
Yeah, I mean, they certainly can be, but I don't think that they have to be. I mean, certainly as communities are going through or a state is going through a clean energy transition, and you're closing down coal plants and other, facilities that have had a big burden on environmental justice communities. Then that clean energy transition is helping those communities in terms of the air pollution, the water pollution that goes along with having a facility like that in your community. But then, of course, you've got the just transition issues in the sense that oftentimes it's people in those that community is getting tax revenues from the facility. They have jobs associated with that. So then how do you do that integrated resource planning that you're making sure that the economic benefits of new generation are going to communities? And also, how do you make sure that the new clean energy generation resources are having positive rather than negative impacts on communities? Typically, you're not going to have you're not going to have the same type of air and water pollution. You might have some aesthetic impacts. That's something that a lot of communities are dealing with right now. One example is Xcel Energy is closing, its biggest coal. It's the biggest source of CO2 emissions in the state of Minnesota. Huge coal plant, the Sherco coal facility, and they're replacing it with a massive on-site solar and battery project that is going, and they're transitioning all the coal plant workers to other jobs within Xcel. And there's going to be a lot of tax revenues associated with the new clean energy development on site. So that to the extent you can swap out one for the other, that on the same site, then you can actually deal with both some of the environmental justice, energy justice, and just transition issues. So, you know, in the integrated resource planning process, that's something the commission needs to take into account and can.
Excellent. Here's a question that I think is perhaps pretty complicated, but an interesting question. To what extent are public commissions or regulators of the electricity industries their concerns about grid reliability and resiliency in the face of weather disruptions for utilities? How much is this a matter of social policy and energy justice? And or how are we thinking about keeping the grid reliable, or some places more reliable than others, I guess? Does this have precedent, or how are we dealing with this?
Yeah, I think commissions, at least in some states, are doing a much better job of addressing these issues, or at least recognizing these issues. So for instance, DTE, the main investor-owned utility here in southeastern Michigan, you know, there've now been studies that show that, like, in terms of when there's more outages and longer outage times in the low-income neighborhoods of Detroit that were historically redlined, and also that energy efficiency investments have been lower there. And it's like a significant difference. My recollection is there's similar data with regard to Austin, Texas, with regard to that, in terms of where the outages are, how long they last. And in the past, people didn't really necessarily keep track of that, right? That wasn't a metric that a utility had to address in terms of reliability. I mean, and you didn't even necessarily have access to that data to break it down by neighborhood that way. Now it's becoming a much more central part of audits. They just did an audit of DTE that the commission ordered to look at some of those issues. And there was also a recent settlement involving DTE where there's going to be enhanced energy efficiency and weatherization investments in those historically redlined neighborhoods. So that kind of goes to both the recognitional justice and the restorative justice tenets. So I mean, I'm seeing that in a lot of different states, and I think that's why it's so important for advocates, for commissions, and for utilities as well to be focused on those issues.
Right. I think there was some discussion after one of the recent hurricanes here in Texas that CenterPoint had invested in some mobile backup generation type systems, and they weren't used sufficiently. And I think there was like these discussions on whether how to deal with that they've approved these things, and then maybe they didn't get used properly. I don't know how much it has to do with the energy justice type of issue, but it's certainly a choice on investment to maintain reliability, and, you know, in a at least in a general service sense. So yes, it can get, sounds complicated. Here's a question about municipal electric utilities, or perhaps cooperatives, and how that might be have some different context in what you're describing. So I'm here in Austin. We have a municipal electricity utility, Austin Energy, and they have, according to this person, this comment here, a very generous redistributive low-income rate that would probably not be permitted under the just and reasonable clause of many utilities. So do you think municipals are perhaps laboratories for social policy, or do you see, is this a pattern that municipalities maybe have a little bit more progressive low-income, for example, or equity type programs than other utilities? Is there any differences there?
Yes, there's a lot of differences for the same, you know, reason that the questioner said. I mean, they basically the city or the utility board, however it's set up, and it differs from city to city, they can set the policy, right? And they can do that without, in almost every state, being overseen by either the State Public Utility Commission or the Fed or by FERC. So that's excluded from their jurisdiction. And you see a lot of innovation by municipalities. I actually have another article that's called Local Power that talks a lot about the role of municipal utilities, both in terms of dealing with some of these energy justice and low income issues in utilities, but also how municipal utilities have a lot more independence from the state generally, particularly when you have a city, and I guess Austin, Texas could be an example of this, where you have a city that has very different policy preferences than the state in which it's in, the state legislature can engage in a lot of preemption of or displacement of municipal local policies. But I would argue, and we argue this in the paper, much less so when it comes to a municipal utility, as opposed to a utility as opposed to a municipality just making other types of policy decisions, because when a municipality as a utility is acting in a proprietary capacity and kind of a business-like capacity, not just a regulatory capacity, which actually can insulate it from state politics a little more. So yeah, I think municipal utilities are fascinating. It really depends on the city politics, right? In terms of whether you're going to get some of the results that you might want to see around low income rates or energy justice. But I think on the whole, the questioner is right to focus on the differences there. You see that a little bit with rural electric cooperatives, and Gabe and I have another article about clean energy transition in rural electric cooperatives. But there, again, you have some different considerations.
Right. Well, you bring a great point. I'm at least aware of the Texas legislature sort of overturning a citizen voting on a referendum in Texas about disallowing hydraulic fracturing. That was about a decade ago. And then, yes, there are always discussions about, or sometimes discussions about whether Austin Energy is working properly, and some people trying to convince it to become part of the larger market for reasons you nicely summarized. Maybe I'll close on one question here, which is a little bit about some of the, or at least could touch on it if you wanted, issues of this cost causation. There's different kind of rates that apply that utility commissions have to decide in a generic sense, commercial rates or industrial and residential. It could get perhaps more complicated than that. And the buzzwords of the day, artificial intelligence, increasing loads on the grid that maybe we weren't thinking that much about just a handful of years ago. And that might, companies might be asking for certain types of investments in the electric grid. So any thoughts about difficulties or issues in dealing with cost allocation and long-term investments for something that, we think will be around for a long time, but, it's new and we don't know.
Yeah, lots of thoughts on that, because obviously it's in the paper so much today. So, after, decades of pretty flat demand, all of a sudden, almost out of nowhere, now load growth through data centers and AI. And so what do we typically, you would have these new sources of electricity be asking for economic development rates, and they have been given economic development rates in a lot of states, but now a lot of states and utilities are like rethinking that, right? I mean, my understanding in Texas is the response is starting to be, hey, we don't have space for you. You got to have your own behind the meter, generation plant. That's never been done before. So maybe, or utilities proposing, well, okay, we can hook you up, but we're going to charge you more, right? So can you have a higher rate for new load? Does that violate the non-discrimination policy? So I think we're kind of in, I don't know, I want to say new territory. But once again, what are just and reasonable rates? What's discrimination? Are some electric loads more important than others, right? Can we distinguish between those? In the past, we just always built enough to accommodate everything. That's a little more difficult today, particularly as we're already trying to build a lot of renewables to displace carbon emissions, and also how much we've had predictions of significant load growth in the past, sort of in the early days of computers that didn't come about. What can we do with energy efficiency and demand response, and what requirements with regard to energy efficiency and demand response can regulators and utilities impose on new loads? So these are all emerging questions that are going to have to be addressed.
Right. Well, let me be aware here in Texas that there is a prioritization, at least in an emergency situation, for natural gas consumers. And we learned this during Winter Storm Uri in 2021. Maybe not so much for electricity. So we'll end it there. Thank you very much. It's been Alex Klass, who's professor of Law at the University of Michigan Law School. I think it's been a very interesting, jam-packed full of information and informative session. So thank you very much.